Mr. President.
The Honourable Adam Searle.
Thank you, Mr. Assistant President. I lead for the opposition on the Electoral Bill 2017. The opposition does not oppose the bill. The New South Wales Labor Party made submissions on the draft bill, and a number of those submissions have been incorporated in the version of the bill we have now before us, and we commend the government in responding in that positive way. The electoral laws of this state should not be a political football. The object of the bill is to make provisions for the conduct of state parliamentary elections. The bill repeals and replaces the Parliamentary, Electorates and Elections Act 1912. It is based upon a number of reports from the Joint Standing Committee on Electoral Matters, on which the Honourable Peter Primrose and the Honourable Courtney Houssos have served, and I note the shadow attorney in the other place also served on that same committee from 2012 to 2015. And of course it's based on other suggestions from the New South Wales Electoral Commission and of course more widely. Self-evidently, the legislation that this bill repeals is over a century old, and it looks it. A series of amendments and changes over time have not made it clearer or better designed, and has necessitated an overhaul. The Joint Committee's intention and the government's stated aim in introducing a modernised version of the legislation is, we think, a good objective. The government presents the bill as a modernised version of the existing law, largely based on the current position, with a number of useful, if not life-changing or earth-shattering improvements. We agree with that, with those objectives. The committee chair's forward at page Roman numeral 8 of the report stated that, and I quote, "Whilst the essential principles of our representative democracy remain valid, the legislative framework through which they are given effect requires modernisation," unquote. We agree with the substance of that comment. While the government places great emphasis upon its reliance upon the Joint Committee's reports to develop the provisions of the bill, it's certainly not the case that all the committee recommendations in their entirety have been adopted, and given the high number of recommendations and the complexity and importance of the subject matter, it would be nothing short of extraordinary if all of them were adopted completely. For example, recommendation 19 of the committee's report on the administration of the 2015 New South Wales election and related matters recommended that the government increase the number of required nominators for independent legislative council candidates from 15 to 100. Clause 83 of the bill does something else and says there are 50 rather than 100 nominators. And I notice that's also been the subject of change. So we think the government, rather than the committee, has got the balance right on these changes. Recommendation 6 of the committee's 2015 election report made some cautious commentary about iVote, and again, we don't disagree with those provisions. The most significant discrepancy between the committee's recommendations and the provisions of the bill, however, which deserves some comment, relates to recommendation 1 of the 2013 report, which states, and I quote, "The New South Wales Government introduced legislation for a new Electoral Act for New South Wales, which provides for both the conduct of state elections and the regulation of campaign finance and expenditure," unquote. This bill does half of that by repealing and replacing the Parliamentary, Electorates and Elections Act, but leaves untouched the Electoral Funding, Expenditure and Disclosures Act, which of course would have been a much more challenging task to undertake, particularly in the time frame. So I would ask the Parliamentary Secretary in reply, if possible, to indicate whether or when the government intends to bring forward an overhaul of the Electoral Funding, Expenditure and Disclosures Act, or if it does. In accordance with modern practice, the bill adopts an objects clause. Its definition, provisions clarify and aim to simplify the terms used in the legislation in a range of ways that I won't go into. The bill continues the provisions for the registration of political parties with what looks to be an enhanced capacity to obtain information from parties. In relation to the conduct of parliamentary elections, the Electoral Commission is provided to be the returning officer with the appointment of officials to assist. The issue of writs for the normal 4-yearly elections is set for the Monday following the expiry of the Legislative Assembly. That's sensible. This allows more time to publicise the date for the close of authorised rolls. The opening of nominations is allowed before the issue of writs for general elections. This can allow a longer period between the close of nominations, the subsequent ballot draw and the opening of a pre-poll. There are changes concerning child-related conduct, with which we certainly don't object. The Electoral Commission will have powers, with the approval of the Secretary of the Department of Premier and Cabinet, to requisition halls and rooms as voting centres because the features of the facilities, for example wheelchair accessibility, or if other premises in the district have become unavailable due to fire, flood or other emergency and no alternative is reasonably available. A voting centre cannot be a room or hall used exclusively for religious or residential purpose. purposes, no cost is payable except reasonable costs for lighting, heating, air conditioning or cleaning and the cost of repairs. Disputes about the amount payable are to be resolved in the local court. The bill remakes the provisions for the Court of Disputed Returns. There are new provisions about prosecuting parties that are unincorporated associations. Part 10 of the bill has various miscellaneous machinery provisions that include a regulation making power, and I note that penalties for electoral offences have been maintained. The draft bill did seem to reduce a number of existing penalties, for example in clauses 183, 186, 187 and 195 of the draft bill, but as I will briefly touch on, those changes have been abandoned by the government, and we certainly welcome that. As I indicated, the Australian Labor Party New South Wales branch made a submission, and it's worth just touching on some of those. For example, Section 66 of the bill required that the registered officer of a political party must make an application to amend its particulars and the register of parties within 10 days of an amendment. The Labor Party considered that 10 days was an unreasonably short period within which to finalise amended rules for lodgement with the Electoral Commission. For example, such a short time frame would not allow an appropriate time for internal checking. So the government has extended it to 21 days rather than, I think, the 2 months that we had suggested. But I think that's the fact that the government positively engaged was worthwhile. We also had some concerns about whether it should be a notification or a proper application, and the government has indicated that there would be no change on that because the Electoral Commission would be likely to refuse an application to change the name of the party to the name of an existing party if there was an application made during a freeze period, or that it wasn't merely a notification, it was the capacity to make substantive changes, and therefore we note the government's reasoning and we won't agitate that issue further at this point in time. We also had concerns about the new provision in 180H of the bill that provided that non-complying electoral material would include material that, and I quote, contains a statement intended or likely to mislead an elector that the material is an official communication from the Electoral Commissioner or the Electoral Commission, unquote. The Labor Party provided a response to the inquiry into the 2015 state election by the Joint Standing Committee on Electoral Matters that outlined some concerns in relation to other parties' conduct, and we certainly welcome stronger provisions to prosecute such behaviour, but we were concerned that the framing of the provision might overreach. For example, we were particularly concerned that, and we're mindful that it's a key function of registered parties to remind and inform voters about elections and what they should do, and the Labor Party did request that the proposed provision be amended so that where the material has been clearly authorised by a political party, the material did not breach 180H, or to be amended in a way that only included false statements. The government hasn't taken up our suggestions on the basis that material clearly authorised by a registered party would be unlikely to be found to fall foul of the provision, but they thought that the proposal about limiting it to only false material would have been a weakening of the provision, so I'm sure this is an issue that will get exercised in the practice of elections. So we will see. We also had some concerns about the way in which Section 210, which was replacing the existing 151 of the Parliamentary Electorates and Elections Act, specifically 210(1), seeks to provide, and I quote, the free exercise or performance by any other person of any political right or duty that is relevant to an election under the Act, unquote. And the Labor Party supports that objective, but considered that the drafting was ambiguous and that it was unclear whether the provision would be limited to activities in direct connection with an election or whether it could have application, for example, to the internal processes of registered parties, such as pre-selections. And the issue was raised at budget estimates with the Premier and the Electoral Commissioner, but wasn't resolved there. And the Labor Party made some suggestions that the 210(1) be amended, and the government has in part taken the Labor Party's proposal on board for that, and in relation to the diminution of the maximum penalty, the government has, on second thoughts, decided to retain the existing penalty, and we certainly welcome that. There were a range of proposed reductions in maximum imprisonment penalties across a range of provisions in the bill that the Labor Party did not support. At present, anyone who prints, publishes or hands out unauthorised election material of the type that was witnessed in federal and state election campaigns, for example, in Lindsay and East Hills respectively, faces significant fines and a sentence of up to 6 months imprisonment. That penalty was removed from the draft legislation, and additionally, under the proposed amendments, the maximum sentence for the offence of electoral bribery was reduced from 3 to 2 years. The proposed decreases in maximum penalties of imprisonment came at a time when the Electoral Commission had confirmed that it was investigating highly inflammatory, homophobic and unauthorised election material aimed at Labor candidates in recent local council elections in Sydney aimed at Chinese-speaking communities. Not only did we consider that was a weakening of important integrity measures, and we found that to be of great concern, of equal concern, we thought was that neither the Electoral Commission nor the Premier nor her departmental secretary, who were at budget estimates, were really able to explain how or why those changes came about. Nevertheless, again, I recognise that the government has responded constructively and have taken those suggestions on board. As with the reduction in the maximum jail penalty proposed in the original 210 of the bill, the Labor Party considered that any actual perceived weakening of the consequences of undermining the integrity of our democratic processes must be avoided. The bill is an opportunity to improve public confidence in the electoral system by strengthening both the processes and the penalties for breaching the law, and in its original form the bill in many sections appeared to do the opposite and appeared to send a green light to those who would corrupt or undermine the integrity of the electoral system, which we said should not be permitted, and we welcome the government's positive response to that. In relation to the issuing of penalty notices provided by Section 2, or Clause 263 of the bill, we were concerned that the ability to issue penalty notices was too widely cast, and I note that the power to issue penalty notices will now be restricted to authorised officers, being inspectors within the meaning of Section 110 of the Electoral Funding Expenditure and Disclosures Act 1981, which we think is a suitable response to the concerns that we raised. There were other matters raised in our submission, but those were the key concerns, and as I said, we are content that the government has constructively engaged with the official opposition and has taken on board our key concerns. As I indicated at the outset of my contribution, Mr. Assistant President, the opposition does not oppose the legislation.